Morning, everyone. My name is Trish, and welcome to our webinar, Employment Relations 101 for Employers. Thanks for joining us today. We will get started soon, but we're just going to wait a few minutes for a few extra people to join this session, if that's okay. Okay, it looks like we have a few more people who have joined us. That's fantastic. If you missed the beginning, I'm Trish. Welcome to our webinar, which is presented by Citation Group, Employment Relations 101 for Employers. If you find the world of employment relations complex and confusing, or perhaps you just want to strengthen your knowledge of workplace law, employment contracts, and policies, then this webinar is for you. Welcome, and we're glad you're here with us today. Before we begin here, there are some housekeeping rules. So if you have any questions, please type them in the question and answer section below, and we will try and answer all of them, but at the end of this presentation, if that's okay. This webinar is recorded and you will be sent a copy of the session. So if you can't stay for the duration of the whole thing, that's fine. We totally understand. A little bit about me. I am a business development manager at Citation HR, and I work with businesses to help them uncover any blind spots or gaps that they have around HR and health and safety and find solutions that work for them. Co-presenting with me today is Jess, a senior workplace consultant here at Citation HR. She loves helping our clients achieve workplace compliance by way of interpretation of relevant employment legislation and case precedent as it applies to the Employment Relations Act. She particularly enjoys researching and explaining new or hot topics when it comes to workplace compliance. For over 30 years, we have been working to help our clients build better businesses by providing strong workplace compliance solutions. From outsourced HR solutions and safety management systems to ISO certification, Citation Group can support your business. So just a little bit about Citation HR, a brief rundown on what it is we do here and the features and benefits of those using our service. Citation HR is an external extension of HR. We understand that you don't want to be spending too much time meeting legislative requirements. Ideally, you can spend that time growing the business. So that's where we step in. How we do this is that when someone comes on board with us, we perform a comprehensive HR compliance audit. This will help us diagnose any blind spots or gaps in your HR documents and processes. We'll then work with you to fill those and make sure you are meeting your legal obligations and best practice. You will also have access to our 24/7 advisory service so that at any time of the day, you will have access to qualified professional advice on the phone or through email. This gives you peace of mind, knowing what you are doing and saying is best practice to mitigate risk to you and your business. You also get access to our Citation HR software. This is an online platform for you to manage and track, record employee data. It also guides you through the process of onboarding and offboarding employees and managing the life cycle of the employee. It contains legally compliant templates and letters, information and resources, which is updated regularly. Finally, we have the insurance and representation, which means that if you were ever in the middle of an employee-related claim, your business has the protection that it needs. Today's agenda. Thank you. Next slide. Yep, appreciate that. Today's agenda. I'm just going to hand over to Jess in a sec, but we're going to go through the New Zealand Employment Law Framework first. That's going to be followed by the employment contracts. We're going to have a little chat about those. Then we're going to jump into the policies and procedures. And at the very end, we're going to answer some of your questions. So don't be afraid to pop any question into that chat down below. This gives us a good chance to get an understanding of what's going on in your business and perhaps address some of the challenges that you're facing. Over to you, Jess.
Thanks, Trish, and hello, everyone. Thank you for coming today. As it was mentioned, we are first going to talk about the New Zealand employment law framework. The way the New Zealand constitution or framework is set is that Parliament creates legislation. Legislation is then tested by parties through the courts, and this is what is known as common law. Legislation governs common law, which tells us how the legislation is to be applied. Thereafter, parties are bound to contract law. It is important to know that parties cannot contract out of legislation. Some important pieces of legislation to note are these on the PowerPoint, which is the Employment Relations Act, the Holidays Act, which is regarding all the leave entitlements. Wages and Protection Act is for the purposes of protecting remuneration. Parental Leave and Employment Protection Act, Human Rights Act, Health and Safety at Work Act, Minimum Wage Act, and then common law and contracts underneath. So please keep these in mind when you are managing your employees, creating contracts and policies, and also the rest of these PowerPoint slides will refer back to legislation in some way or another. Some fundamental concepts of New Zealand employment law or New Zealand employment framework is good faith, fair process, and good reason. Good faith is commonly known, commonly used. I'm sure you guys are all familiar with it. This underpins every New Zealand employment relationship. It requires parties of the employment relationship to act honestly, openly, constructively towards each other. And it's a critical concept when performance managing or disciplining or any kind of process that you manage the employee. Failure to comply with this obligation forms the basis for most personal grievances. Fair process. This applies when taking action that negatively impacts the employee. This subsets overall good faith obligation, requiring transparency, being communicative, and working with one another. This applies when managing performance and conduct, considering termination and implementing workplace changes, including disestablishment of roles through a restructure process. Good reason. This is for action against an employee that can only be taken for a good reason and valid reason. Test for justification. This is Section 103A of the Employment Relations Act 2000. This is where every employer's decision is measured against, most commonly through personal grievances or when the company is being investigated for a process. The test itself is how well did the employer investigate? Did the employer put it towards the employee? Did the employer consider any feedback the employee gave? Did the employer make a fair decision in the end after all of that? And then you move into the procedural side of it. Was a fair process followed? This is important when you're doing a process that negatively affects the employee, such as disciplinary performance management, anything that might outcome in a warning or dismissal. And of course, good faith is required through all of this and procedural fairness. Substantive must be a good reason what a fair and reasonable employer in the same circumstance could have done. So did you do everything that a fair and reasonable employer could have done with the information they had in that specific circumstance at that specific time? So these are things all that will be looked at for any decision that you have made against an employee, process-wise, outcome-wise, if something is raised. Employee entitlements. So for any employment relationship through the legislation, your employees do get minimum entitlements. Some of these are 4 weeks of annual leave, 10 days of sick leave, bereavement leave, family violence leave, parental leave of any kind, and 12 public holidays. These minimum entitlements, you need to ensure that your staff are, if they become entitled, they are receiving them in some way or another, or if they meet the criteria. So just keeping an eye on your employees' entitlements here. When it comes to close down, I just wanted to put this in today to make sure it is across. We're coming into the summer season. A lot of businesses tend to close down or have Christmas close down across that period. When it comes to close downs, there was a case that came out in 2020, this case here at the bottom, which determined if an employee has no entitlement to annual leave when it comes to your close down period, you must pay out 8% of gross earnings since that employee's last anniversary date to the close down date or from their start date to the close down date. So that's any of your employees that haven't been working with you for 12 months when your close down comes, or any employees that have used all of their annual leave when the close down comes. So this is always, it's been in legislation for a long time. However, it's been untested. Up until 2020, it got mixed in with all the COVID scenarios and legislations coming out. So it did get lost. But however, I'd just like to keep reminding employers of this as we get closer to the time. So please look into this, make sure you are being compliant when it comes to close downs. The contract of employment. What kinds of contracts are there? So we have permanent, fixed term, casual. Permanent is for permanent part-time, permanent full-time. It's the same kind of contract. They're both permanent. Fixed term, this is when there is a specific start and end date for a genuine reason. And a casual is as and when required, no expectation of future work, no obligation of work, no obligation to accept work, and no pattern. What makes an employee casual? There's no, as mentioned previously, there's no expectation of ongoing work. There's no regular work pattern. The employer can offer or not offer work depending. The employee can refuse assignments. The employee gets paid 8% of their gross earnings on top of their wages because there's no future expectation of work, so no accrual of leave. Each engagement is seen as separate employment, to put it in that frame. So each engagement, you need an employee to cover for someone that's off sick today. They're a casual coming in. That one day, that's one engagement of employment. They come in the next week, it's not continuous, they're separate engagements, and that's why you pay out 8% of gross earnings. And this is all reference to a true casual. What makes an employee a true casual? What makes an employee a fixed term? There's a start and end date. There is genuine reasoning, such as project, covering someone on parental leave, busy period, as long as it's genuine business reasons. Dangers is rollover and leave accruals. With rollover, this is where I mean if an employee on a fixed term works one day over their fixed term end date, they are automatically a permanent staff member with you. They've worked over their terms and it does revert back to being a permanent. Rolling funding, for example, this is where back-to-back fixed terms are handed out because funding purposes. Funding is not a genuine reasoning for a fixed term. So this is where the risk comes in. I would advise tying it to a project rather than funding itself. But flipping it back, even if it was a genuine reason and you were rolling over back-to-back fixed terms, there is still risk there and there is still argument. Is it a genuine fixed term? How come it's not permanent? And when the company can no longer afford, have the need for this role, go through restructure redundancy. Was there a genuine need for a fixed term or could we have done it another way? So just being careful of rollover either way, just making sure that you know when they're going to end and making sure they don't show up to work the next day. Or if they are rolling over into a different fixed term or an extension, making sure you have that signed prior to that date. And when it comes to leave accruals, this is where the danger comes in of financial danger. So if you have a fixed term working with you for 10 months on a project, and then they roll over or extend in some way, and they hit that 12 months, 4 weeks annual leave entitlement, but you were paying out 8% on top that whole time. Unfortunately, the company just has to bear the cost. They've hit the legislative 12 months, you get 4 weeks annual leave. The company paid out 8% on top previously. You are not going to get that back, but they must get their 4 weeks annual leave. So just keeping that in mind. Okay, I'm just going to have a break here. I'm going to pass to Trish for 2 minutes. So thank you, Trish.
Thanks, Jess, for a very informative session so far. Some great takeaways for us all. Okay, so we're just going to pause here for a moment to share an exclusive offer. If you've got any questions about managing workplace compliance, here's a special offer for you. We're offering everyone on today's session a complimentary consultation call. This is the perfect opportunity to discuss your business's compliance, understand if you have any glaring risks, and we can share our knowledge with you. We'd love to be able to assist you. So simply scan the QR code on the screen, and if you're on a mobile, you can click through using the link in the chat box below. Also, for today's webinar, we're giving away a $200 e-gift card to one lucky winner to go into the draw to win. Simply book in a workplace compliance consultation by the end of the session today. I'll give you just a minute to complete the form, and then we can get back to the presentation. While you're doing that, remember to pop in any questions that you might have below, and we can get to those again at the end. I'll give you some time to do that. Okay, hopefully you've all had time to scan that QR code. Looking forward to meeting you, and I'm going to pass the time back to Jess. Thank you, Jess.
Thank you, Trish. Isn't that an exciting offer? Now, we were discussing all types of contracts, but how do we manage contracts correctly? If an employee is not managed correctly, there's risk that their true relationship does not reflect their contractual terms. Therefore, that leads to risk down the road for the employer. We're looking at casual and fixed term specifically. With a casual, the pattern of work will be noticeable if the employee is offered and they accept opportunities to work on the same days of the week. For 3 to 4 consecutive weeks is the time frame to look at. Where this pattern begins to emerge, beyond this length of time, the employee may form a belief that this is their regular day, regular pattern, regular hours, and therefore they would move forward holding the expectation that they're going to get that work, they're going to get those hours all that day. However, also a pattern of work may arise if an employee is offered and accepts the same amount of hours a week. So not necessarily days, as mentioned before, so not days of the week, but hours per week. If you've got someone working a casual 10 hours a week for 5 weeks, they could have claim to that 10 hours a week being theirs. They're expected to work it. They expect the money's coming in from it. To correct this relationship, number one, I would advise moving them to a permanent contract, whether it be permanent full-time, part-time, use your judgment there, and making sure you look at the leave side of this. So with a casual, you're paying out 8% on top. If you're moving a casual to a permanent, making sure that their leave reflects when the pattern arose. So you've got an employee moving to a permanent, their commencement date might not be the day of signing the permanent agreement, but it might be the date the pattern arose. So they were still casual at the start of this month. However, the pattern started at the start of this month. So we're going to make sure the commencement date is that date. And therefore they start accruing leave from that date. You may be paying leave twice, but unfortunately that's just the cost of having an employee on a wrong contract. The second option is to retain the employee as a casual, but stop offering them work and kind of bring it back to a true casual relationship. The risk here is that the employee, if they want the hours, need the hours, expected the hours, they then might go and get legal advice and you might be dealing with that situation that ways. Of course, you can try to rectify that internally, and hopefully they raise it to you internally before taking it that far. But there is also that option there. More risky if there has been a pattern, but there's the option there. Another thing with casuals is if a casual employee establishes a pattern of work, they may have legal right to claim payment on a non-worked public holiday that falls on the day of their regular working day. Or they even get paid alternative day if they work that day. So just bearing that in mind with casuals as well. Moving on to fixed term, it's really important to spend the time considering, is this fixed term really necessary? Is this genuine reason? Is there a specific start and end date? Can we tie it to something? Really just checking that you are putting in place a fixed term that is genuine and it isn't going to cause you risk down the line. If there are no genuine reasons, they're not in the employment agreement itself, or the reasons don't link to the specific details or dates of the agreement, the employee can elect to treat their fixed term as a permanent. So being a permanent staff member with you, same as mentioned previously, if they work over 1 day over their fixed term, or they have argument that this fixed term is not genuine, they have argument to be a permanent employee with you. You might then again double dip into the annual leave side of things and entitlements. So it's just being cautious when it comes to fixed terms and casuals. To manage contracts correctly is crucial. At the end of the day, the way to fix a incorrectly managed fixed term or casual is to turn them to a permanent. So if you're not wanting a specific staff member to be permanent, don't have the role, whatever the purpose might be, make sure you are managing it correctly so they don't have right to claim being a permanent employee with you. One way to make sure you are managing contracts correctly is through payroll monitoring. This is very thorough. The numbers don't lie. Notifications are there if you need. For example, fixed term, make sure you are notifying yourself when their last day is, making sure there's some kind of notification or just flag on their account. For casuals, keep looking at their 5 weeks last worked. Have they worked regular hours or patterns? If at 3 weeks you start seeing it happen, let the manager know or start managing them differently and bring them back to being a true casual. So making sure you are really utilizing your payroll system and making sure you are managing those contracts correctly. Well, final slide on contracts, essential contract terms. So this is what must be in your employment agreement. So we've got the names of the parties, the description of the work being performed through a job description, position description, indication of location of work, agreed hours as per section 76C, remuneration, employment relationship problems. We're looking at section 50 of the Holidays Act, which is the details to the time and a half payment of the public holidays, start date, pay and payment details, employment protection provision, rest breaks, and if it is a fixed term, you want the start and end date. We also want to make sure that you are record keeping so that you have all your employees, past and present, within the last 7 years, you have all of the agreements on file. This will then turn into a $1,000 infringement fine if you do not or cannot provide those when asked. Optional clauses in a contract is trial and probationary period. They are optional. You don't have to have them in there, but it is best not to have them both. So have one or the other. Then there are leave provisions. They're optional, don't have to be in there, but you're enlightening your staff member of what each leave means and what they're entitled to and how they use it. Availability is not needed unless you need it in your business. Overtime, again, not needed unless you need it or want to provide it in your business. And then confidentiality and restraints, again, not needed unless you need it in your business. So these are the essential and optional terms to have in your contracts. And now we are moving on to policies and procedures. What are they? So policies are second to contracts. You must have a clause in your contract that points to policies that are a part of the contract or form the contract. You can only change a term of a contract by agreement. However, a policy can usually be changed at the employer's discretion following a consultation process. I say usually because we want to wait for feedback and hear what the employee has to say, following a fair process and acting in good faith. A policy is a set of rules or principles to be followed in a particular business, and a procedure is the way something is done. Benefits. So policies and procedures are an important tool for managing your employees. They work alongside the employment agreements to make clear expectations for both parties and hopefully minimize disruption throughout the employment relationship. They reduce risk of misunderstandings. They ensure fairness. They give you a good reference point to confirm what you're thinking, and also to comply with relevant legislation. They help you get consistency across the board. Thinking about how you want your business to run, documenting it and sharing it with your employees will save you a lot of money in the long run. When you are creating policies and procedures, you should make sure that they are consistent with your employment agreements. So that is crucial and foremost, making sure they're aligned with what your employee is signing up to anyways. You don't want contradicting of, for example, if you're calling in sick, the contract might say you must call in 2 hours before your shift through text or call. The policy might say you must call within 4 hours of your shift start time, which is a direct call to your manager. No texts are allowed. So you want to make sure that your policy aligns with the contract that they've signed. And this can be hard if you're changing a policy later on. Someone's contract says something else. It's just navigating those case-by-case scenarios. You want to make sure it's suitable for the business. You want to think about what you're trying to achieve. You want to make sure it's fair and reasonable, making sure that it's people are following it, that it's achievable to follow. You want to consult with your employees when implementing any policy or procedure following that test of justification. And then you want to finalize the policy and then publish the policy with an implementation date. So these are things to consider, and this is kind of also the process of what to do when implementing. Again, test of justification, follow that consultation process when kind of changing anything in their business. So suggested policies and procedures, if they apply, I've just jotted down the most commonly known and commonly used. However, you can change titles, you can implement new ones, whatever the business needs. Common ones, however, code of conduct, disciplinary, health and safety, holidays and leave, hours of work, information security, internet, email, social media policy, leaving the business, performance appraisals, recruitment policy, resolving employment issues, training and development, travel, equity, use of company equipment, and how to handle customer complaints. These are just common examples, but you can create or add or change throughout your business's life to whatever the business needs at the time following consultation. That brings me to the end of my slides, and I'm going to pass back to Trish again for a couple of minutes.
Thank you again, Jess. You are such a wealth of knowledge. That's amazing. Just a reminder that we are giving away that $200 e-gift card to one lucky winner. To go into the draw to win, simply book in for a workplace consultation and compliance session by the end of our session today. QR code is now on your screen to scan that, and I'll just give you a minute to complete that. If any questions have come up, again, populate those down below because we're just about to chat about the ones that we've gotten so far, which will be exciting. All right. We'll start on questions, Jess, if that's okay with you. But here is the first one. I've got someone on a visa and they cannot be hired under a permanent contract. Can I hire them on a fixed term contract? Over to you, Jess.
Good question. So, believe it or not, but a visa reason is not a genuine reason for a fixed term. So, unfortunately, this is where immigration law and employment law contradict themselves, and it makes it almost impossible for employers to give work to these overseas workers. But so it needs to be genuine reasoning to be a fixed term. If you can tie it to a project, great. But otherwise, the visa itself is not genuine reasoning. So I would stay clear of that. If you are unsure, or potentially follow up and get more advice around your specific situation with immigration or with a employment law specialist, whether it be through citation.
Thank you for that. Right, we have a second question. And the question is, I have a casual employee who works Saturdays. They are no longer performing. Can I terminate their contract? Over to you, Jess.
So this question brings up a lot of questions myself. So when you say working Saturdays, how long have they been working Saturdays? You know, if we go back a few slides, is it 4 weeks? Has it been 5 weeks? So let's say it has been a few weeks. If they work every Saturday, they're most likely permanent, going down to that argument. So they might be permanent part-time, 8 hours. Therefore, if they're underperforming, you should go through a performance improvement plan. If they are a true casual, however, so it is a as required basis, there's no expectation of work, then just stop offering them work. Just stop offering them work. You don't need to go through a process if they are a true casual. The risk for stopping work is if a pattern has come about. If the working Saturdays has come about, that's where the risk is to stopping work.
Thank you for that. And we've only got time for one more question. And that question is, Jess, my employee is asking for their wage and time records. What should I do? Thank you, Jess.
Okay, so good question. This takes you back a few slides with that $1,000 infringement fee. Similarly here, you were required to have all records on file, and if you are requested to provide them, you must do so within 10 days. Otherwise, fines will take place. And there may be a personal grievance being prepared in the background as why they're wanting that information, and you're just giving them more to kind of add on to their personal grievance. So making sure you provide everything when it comes to wage and time records, and within 10 days, whenever asked. That is their entitlement to ask.
Thank you, Jess, for that. And thank you, everyone, for attending today. As I said, that's all the time that we have, those questions. However, we would love for you to book in a consultation, a complimentary consultation, to discuss your business further. If you have any challenging questions or challenging situations, whatever that looks like, please feel free to book in for that session. Thank you for attending. Please keep in touch. You've got details on the screen of how you can reach out to us. We are here to help.
Thank you, everyone.